matter of Test Valley Borough Council and Test Valley Borough.
Mr. Green.
May it please your Lordship, I appear for the appellant with my learned friend Mr Williams, the respondent is represented by Mr Burke. The interested party has taken no substantive role in this.
Yep.
My Lord, in addition to the three bundles, the authority bundle, the supplementary and core, we have handed up, or proposed to hand up, a clip of plans.
Ah, fantastic.
They are A3 versions of the A4 plans that appear in the bundle. I
Yeah.
hope they'll be easier to understand.
So this is what's on our desk now.
My Lord, yes.
Thank you.
A clip of plans with an index. And I hope from both it's easy to understand what has been permitted where.
And will that show us what the position was immediately before the grant of the disputed decision?
It will show what was permitted immediately before the grant of the disputed permission, yes.
But will it show us what was happening on the ground at that stage?
All of that.
All right, okay, fine.
And well, what was happening on the ground is, I think, common ground, not material to the determination.
Right.
My Lord, the appeal raises essentially four grounds of challenge. First, whether as a matter of law any conflict between the operative wording, as it's been called, of a permission and its conditions is unlawful. Secondly, whether in this case the removal of the substation, the permitted substation from the 2022 permission, amounted to a fundamental alteration.
Could you say that again, please? Whether the removal
of the substation from the 2022 permission amounted to a fundamental alteration of the development permitted by the original permission.
does that really mean whether the non-inclusion of the sub? Yes.
Yes, the omission of it.
The omission. Sorry,
Yes.
that's better. Thank you.
The third is whether in granting the 2022 permission the council failed to have regard to the fact that it was omitting the substation. And the last is whether if the council had been aware of it, it would have made a difference to the outcome. And my lords, I propose to address your lordships on grounds 1 and 2, and Mr Williams will address your lordships on grounds 3 and 4.
Thank you.
Can we turn straight away then to the impugned planning permission, which is in the core bundle, tab 17, page 239. It's a fairly typical planning permission in that one has, under the heading Notice of Full Planning Permission, a description of the proposal. Because this was a Section 73 planning permission, it refers to variations of conditions and so on. But if one reads 4 or 5 lines down, it refers to Planning Permission 15-02591 Fulls, and in brackets, installation of a ground-mounted solar park to include ancillary equipment, inverters, substation, perimeter fencing, CCTV cameras, access tracks, and associated landscape. And that was a description of the development proposal taken, ultimately from the application form.
The grant appears just below date registered.
Well, yes.
And it refers back to the development described in the proposal.
Yeah.
But once in the proposal you've gone through the list of conditions being varied, and the development is described, it's mounted solar park, etc., but no reference to a substation. Is that correct?
No reference to a substation in the conditions.
Or in the grant?
Well, no, the words of grant, the phrase operative wording has been used. I'm going to use the phrase
Yes.
words of grant.
Yes.
The words of grant are the local authority hereby grants full planning permission for the above development.
Yes.
In accordance with the approved plans listed below. And one of those approved plans is the plan that omits the substation.
Yes.
And also subject to due compliance with all the conditions specified hereunder. So no reference expressly in the words of grant to any specific features of the development.
Well, forgive me.
It refers.
It refers, if you go, without taking too much time on this, if you go to line 5 of the proposal, it refers to Planning Permission 15. Well, that's the 2017 permission, isn't it? Installation of a ground-mounted solar park. So it goes through the sort of words you will find in the 2017 permission, but it doesn't include the word substation at that point.
Well, it does.
Does it?
Yes.
Where? Oh, there it is. I beg your pardon. I'm sorry. Beg your pardon. But your point is that when you go further on into the plans, which are incorporated by reference, they don't show any substation at all.
So which site location plan is that which shows no substation?
Page 240, top of the page, it's the last plan for site layout plan, reference number H035706V, 24th March 2022. That appears in the supplementary bundle.
It's what I call for short version V, because there are several versions of H035706, and this is version V.
Yes, this was the final one.
Yeah. Okay.
My lord, also in the clip of large plan, which may be easier to see,
Which,
it's the last plan, Plan G.
so G on the clip.
Yeah. At the top right-hand corner of the plan, it should say G.
Yeah.
And as I say, this also appears in the supplementary bundle at page 203.
And that shows the 76 hectare site.
That shows the entirety of the site.
Yeah.
Running through the site north to south is a power line, shown by two parallel lines. That's supported by pylons, and that's shown by very small boxes within the power lines. And your lordship will see centre left an area where there are no solar panels. And if one compares that with earlier plans, there are some solar panels. If I can...
Has actually, are there any solar panels on the ground now at all?
My lord, I don't know. I think some works have taken place in the location of the substation, but whether there are any solar panels, my lord, I can't say. I can certainly take instructions.
No. Well, I appreciate it's nothing to the legal thing, but it's just interesting to know.
Lord, I'll see if we can obtain some instructions on that. To identify the area of interest, would your lordships go to Plan E? Top right-hand corner, Plan E.
Yeah.
Your lordship will see that most of the solar park is faded, but actually this plan is concerned with the substation development. And it's the area that's much brighter that is the area of interest in this case.
Is this the 2021 permission?
Okay.
Yeah. It's a full permission.
It's a full permission for a substation and some solar panels.
On an area of 6.8 hectares?
Yes. So within the confines of the solar park, and if one compares Plan E and Plan G...
Forgive me, there's a red line on this plan. Is that the boundary of the application site, the permission site?
Yes.
So it includes, on either side of the 132 kV line, 2 areas of solar panels, plus also there's a sort of thin access
Track.
leading to it, access track. But if we go back to the 132 kV headline, just to the west of that, there is another red line which seems to bound the 132 kV substation.
Yes, well, it's confused. There are two red lines.
Yeah.
One shows proposed fencing, and one shows the site layout boundary.
Yeah, but so the second red line I've described is the fencing for the substation.
Yes.
132 kV.
Yes, which includes a 33 kV element as well.
Yes, I think, I mean, it may need to be shown where that was stated to the local authority.
Well, yes. If one compares Plan E and Plan G,
Yep.
your lordships will see that in the area of the substation development, shown on Plan E, when compared with Plan G, there is nothing, no development shown on Plan G. The intention being that the two should operate in tandem.
So the red line for Plan G, the application
Yes.
boundary, permission boundary, is still, was it 72
It's the
hectares?
same,
It's the
essentially
same.
same boundary.
It's the same as the 2017 boundary, is it?
well, yes,
Okay.
but it omits any development within the area covered by the
On the
substation.
layout plan.
Yes.
It doesn't have an area carved out of it.
No,
No. Okay.
Just shows it as blank.
it shows you blank. The intention being that the substation permission should operate in tandem with the varied Section 73 permission.
So effectively, you overlay the permissions when you
Yeah.
come to implement.
Yes, my lord, it's a very undemanding jigsaw puzzle. The two should fit together.
So we go back to 239, do we?
My lord, yes, briefly, one has, as I say, a fairly typical planning permission description of the development, words of grant, conditions, and then notes at the end. And the words of grant refer to the description of development set out above, but the grant is subject to compliance with the conditions. And if one goes to page 240, it's condition 2 that requires that the development shall not be carried out other than in complete accordance with the approved plans. And it's the second approved plan that your lordship has just seen, version V, that the recipient of this permission must comply with.
My understanding of the grant, when it says subject also to compliance with conditions, the conditions don't form part of the grant. That's the law. But what you see just before that, development in accordance with the approved plans, they're incorporated expressly by reference as it happens, and it includes version V of the site layout. So that's the route by which, as a matter of analysis, one says this is not a permission for the substation. Is that correct?
Well, yes, one gets there in two ways in my submission.
Well, maybe.
Either the grant itself is qualified by reference to the approved plans, and they don't show a substation, or the grant is qualified by the imposition of a
If I
condition.
may borrow an expression from Lord Justice Limblom in Barnet Park, simple language, he says, what is the permission for? That's what the grant does.
Yes. Well, it's said against us that what the permission is for is confusing because you have on the one hand a reference to a description of development that refers to a substation, but on the other hand reference to approved plans that don't show a substation.
Because you're in dispute about the law, can I just also ask, there's reference to CCTV cameras in the grant of the original planning permission in 2017. If they were they built, have they been omitted in the last one?
On better construction.
Yeah.
My lord, I think they're included because
Well, the reason, just so that you know, is
Yes.
Obviously this whole area of law developed from the idea that you can't grant with one hand and then cut it away with another. which is not restricted to planning law, although planning law seems to have taken it a lot further than other areas of law. And I just wondered what the position was if you subsequently had a condition saying, actually, you don't need to bother with CCTV cameras because the council have got lots around the area or whatever. I mean, whether that would be justiciable.
Yes. Well, in our submission, the correct test is, does that result in a fundamental alteration of the proposed development? And the removal of CCTV cameras would not, in our submission, constitute a fundamental alteration. So that would be a permissible change.
Thank you. Sorry to add to complication.
Not at all, my lord. Well, I'm going to start, if I may, with the earlier history of the matter, so the 2017 permission on the substation. The 2017 planning permission appears in the supplementary bundle, tab 5. It's similar in form to the one we've just seen. There is a description of the proposal, and it's the same elements as we've seen before, which include a substation. And the words of grant are also the same. All planning permission is granted for the above development in accordance with the approved plans and subject also to due compliance with all conditions. The relevant plan is the first one mentioned in the approved plans, the site layout plan, revision H. And that, my lord, is both in the supplementary bundle behind tab 2, but it's also in the clip of larger plans.
Which one is this one?
In the larger plans, it's the first plan, Plan A. This is the original solar park layout permitted in 2017. And your lordships will see that in the area of interest on the left-hand side of the power line, there are some solar panels. On the right-hand side, no development.
And does this show a substation?
Well, no, it doesn't, because at this stage, the location and details of the substation hadn't yet been fixed. Condition 2 is a plans condition, which requires development in accordance with those plans, including the site layout plan we have in front of us. So far as the substation is concerned, if your lordships turn to page 75 of the bundle, condition 15, your lordships will see that that requires full details of the siting, external materials, lighting, and means of access for the substation to be submitted and approved. The only drawing referred to there, DIS 000,
Yeah.
my lord, that's also in the clip of plans. And it's the second plan. All that shows is the structure for a 33 kilovolt transformer.
Well, it says typical single 33 kV. Basically shows the design for the substation.
It shows the design for a
33
33 kilovolt
Yeah.
transformer or substation.
So why, when the substation was actually built, assuming it has been built in 2021 or after that grant of permission, or 22 was it?
2021 was the substation permission.
Why wasn't that then dealt with as a sort of, well, we complied with condition 15?
My Lord, in terms of sequencing, you have the grant of permission in 2017.
Yeah,
At that stage, the substation, its details were not known. That required discussions with the district network operator, the person responsible for the power cable and so on. But those details were not finalised until 2021, when the application for a more substantial substation development was submitted. So uncertainty about the substation in 2017, that's clarified under the 2017 planning permission by 2020. If one goes on to tab 6,
in the supplementary bundle.
in the supplementary bundle,
Yeah.
that is an approval of details of the substation referred to in condition 15.
Including its siting.
Including its siting. And the plan for that, it's page 86 of the same bundle, but it's also in the clip of documents.
Page C, isn't it?
C.
Yeah.
Blown up plan, one can see the pylon beneath the power lines, and to the right of that red box, that's the proposed siting at that stage.
And is anything said about the voltage on that?
My Lord, the only details approved, as one can see at page 80 of the supplementary bundle, the only details approved are the same plan DIS 000, which is what we've already seen, and the site plan, which shows that red square. Those were the only details approved under condition 15.
So this still refers to 33 kilovolts
It does.
inferentially through the plan. Yeah.
Things moved on, my Lord, by 2020. The developer had discussions with the district network operator about their requirements and so on, and that resulted in the application for the substation permission. The covering letter is at tab 9 of the supplementary bundle.
But we were already in 2020 in divider 6.
My Lord, yes.
And we're going back in time.
We are, yes, forgive me, we are going back in time, but the two applications were being considered in parallel, being promoted in parallel. The covering letter is at tab 9, and one can see in the first paragraph, please find enclosed an application that seeks planning permission for a distribution network operator substation, together with ground-mounted solar panels, ancillary equipment, and so on. And page 88 explains a little bit more under the heading Application Proposal about what the promoter has been doing, discussing the matter with various parties. And it says in the first paragraph under application proposal, it's proposed the renewable energy generated by the solar farm will connect to the 132 kilovolt overhead line which crosses the Woodington site. And then would your lordship read the next paragraph? So, my lord, at the time of the 2017 planning permission, not enough was known about the substation that would be required by the district network operator to connect the solar park to the 132 kilovolt overhead line. The only element that was known about was the 33 kilovolt element. By itself, that's not enough to transport energy from the solar park to the overhead power.
So why, given that was known in April 2020, in June 2020, didn't they say, by the way, we refer to Plan DIS 1000, which says 33 kV, and as you know from April, it's going to be 132?
My lord, I suspect there was a timing issue. Under condition 15 of the 2017 convention, details of the substation had to be approved prior to commencement of the development.
Sorry, under which permission? The
2017 permission,
yeah.
my lord. Prior to commencement of that permission, details of the substation had to be approved. If one goes back to tab 5, page 75 of the supplementary bundle, your lordships will see that condition 15 says that prior to commencement of the development hereby permitted, full details of the proposed siting, etc., shall be submitted to and approved in writing by the local planning authority. And if one goes to condition 1, one can see that commencement had to begin within 3 years of the permission.
All of which is fine, but you knew by April that it was 132 kilovolts, and in June you were referring to a plan which has 33 kilovolts.
Well, I can't speak for the developer, but I assume that the developer was concerned that they might lose the benefit of the 2017 planning permission if they didn't commence the development within 3 years. In order to do that, they had to get the details of the substation referred to, the 33 kilovolt substation referred to, approved by the authority, and that's what they did.
And to commence the development.
And to commence the development.
You have to do relatively
minor works.
Physically.
Yes, and those works have, as I understand it, been done. Knowing, however, that that wasn't going to be enough, they came forward with a parallel application for a proper substation and solar panels and so on. And my lord, the reasoning why this was done appears, I suppose, most clearly from a witness statement. In the supplementary bundle at tab 15, and this is a witness statement that was before Mr. Justice Morris below, and he refers to it in his judgment. Mr. Redpath, who is a director of Woodington Solar Limited, explains the background to the, if you like, the two different substations that came forward. And it's easy if your lordships would read paragraphs 4 to 8.
It may not matter, but as I think I've hinted already, I haven't picked up a document explaining that, a document put before the council explaining that the 132 kV substation proposal included the 32 kV element.
Would your lordship go to tab 11 of the bundle, please?
Yeah.
Which is the report, the officer's report that went to the planning committee that determined the substation application.
Thank you.
And your lordship will see at page 93, the front page, the proposal is the proposal for the installation of the substation, solar panels and so on. And then if one goes on to paragraph 3.7 of page 95, the proposal is described more fully there.
So is it the 6th line?
Yes. In order to export electricity to the grid, one has to increase the voltage so that it matches that of the grid. And as I understand it, that's done in 2 steps. It's increased from the solar panels to a 33 kilovolt transformer, and that's then increased to 132 kilovolts by another transformer, and that's then exported to the grid. So there are, in effect, 2 transformers, each of which boosts the voltage by a certain amount. And it was only at this stage, with this application, that the full details of both elements were known.
3.7 does refer to both the 132 and
Yes.
the 33. Yeah.
Yes. So, my lord, at this stage, there was the 2017 permission, and then there was the grant of the substation permission in 2021, but they provided for different development, incompatible development in the same area of interest, which is what prompted the Section 73 application, which is now under consideration. And as we've seen, the developer came forward with an application under Section 73 with revised plans, and the revised plans show that within the area of the substation permission there would be no development, the intention being that the 2 permissions should operate together.
Can I make sure I've understood one thing, maybe 2 things? If we go back to the 2017 permission, which is in the core bundle at tab 17, and this question really is about what I call the grant for short.
Well, this is the 2022 permission.
No, the 2017 permission.
It's
Maybe
in the
I've given it-
supplementary.
It's in the supplementary bundle, my lord.
I thought that, yes, of course you're right, big pardon.
Tab 5.
Tab 5, yes, thank you, wrong reference. I'm interested in the grant, otherwise known as the operative part. I call it grant for short. The grant was at page 71 for the development described above, which included the substation. thus far, nothing is said about what sort of substation, just a substation. If this document had gone no further to say what sort of substation, as I understand it, you accept that the Section 73 permission granted in 2022 does not include a substation.
Yep.
So there is a conflict thus far.
Yeah.
So in a sense, it doesn't really matter whether the 2017 permission was for a 33 kilovolt substation as such.
Okay.
No. Does it also follow that if at the end of the day you are unsuccessful on ground one, namely there is a restriction 1 in our law, then the appeal fails?
Yes.
Right, just want to be clear. So I may not need to ask the next question, but whilst we're here, what is it that in connection with the 2017 permission, what is it that makes a 33 kV substation part of the grant?
It's referred to, well, a substation is part of it.
Yes, we've got that far.
Yeah. The approved plans include the plan that show a 33 kV substation.
Well, they say this is a typical 30.
Yes.
Yes, but
Right. Well, it would only then be to that extent.
yeah, that's what I
Yeah.
thought.
Yeah.
Yeah. But as we've just discussed, it's academic.
Yes.
Okay, thank you for your help on that.
Mr. Justice Morris dealt with the background facts in some detail, so I'm not going to go through that exercise again. We accept his account of events, but we don't accept all the inferences he drew from the documents, particularly regarding the local authority's knowledge at the time it granted the 2022 permission. It is one of the grounds of appeal that Mr. Justice Morris was wrong to find that the local authority was unaware in 2022 that it was granting planning permission for development that omitted the substation that had been permitted earlier. And we submit that can't be right on the facts. If I can take your lordships very quickly to the officer's report, just a few of the references. I appreciate, of course, my learned friend, Mr. Williams, is going to deal more fully with this.
This is ground 3, isn't it?
This is ground 3. But as we're going through the documents, I think it might be helpful to have a look at this particular document, the officer's report. It's in the core bundle. Tab 18. The proposal is described at paragraph 3.1. And as one can see, the proposal is intended to ensure that the original solar farm scheme can be developed in conjunction with the more recently approved substation and solar array permission.
Sorry, could you give me the reference again?
Paragraph 3.1, my lord.
Thank you, sorry. Thank you.
And that's the reference to the 2021.
Yes. There is then, over the page, section 4 is the history, and as is typical in reports of this sort, there's reference to various planning applications. The most recent one, 4.1, that's the substation permission. And at 4.4, that is the original 2017 permission.
So 4.1 is the 7.6 hectares and 4.4
Yes.
is the full 76?
Yes.
Yeah, okay, thank you.
This application drew objections. This has been a hugely controversial proposal.
I think we picked that up.
Yes. If one goes to page 253, paragraph 6.3, the officer sets out a number of objections. The very first one, validity in section 73 application. The application is not valid under section 73 of the Act. It includes changes to 13 of the 18 conditions, taking more than minor material changes, removing the solar farm's 33 kilovolt substation.
I'm so sorry, could you give me the reference to it?
Well, it's paragraph 6.3,
Yeah.
page 253.
Well, it's really at the top of page 254, isn't it?
Yeah.
It says-
It begins, putting it in context, this is a list of objections.
Yeah.
The very first one challenges the lawfulness of all of this because, amongst other things, there is a removal of the solar farm's 33 kilovolt substation.
But I also on that page note another objection, and maybe the same one, previous applications, if you have that heading, then the bullet, for anyone new to your portal, etc., etc.
Yes.
And about 8 lines down, someone interested in looking through the documents might reasonably wonder where the imaginary 33 kV connection is,
Yes.
detailed in 3.3. So part of the points that were being made was it's unclear.
Well, it had gone.
But one of the things that I was looking for was where the officer advised the members on how to approach these objections. Your 33 kV substation has gone missing. I mean, if the short answer was, well, actually, it's part of the 132 kV substation dealt with by the other permission, it would have been perhaps helpful to have replied along those lines.
Well, my lord, it was dealt with in the officer report. If one goes to page 260, first of all, just to put these comments in context. Section 8, planning consideration, that sets out the officer's assessment of the proposal. And at 8.3 over the page, that describes what is proposed.
Yeah, I mean, even that's ambiguous, though, isn't it? Because it refers to the representations, confirms that a separate planning permission has been granted the 2021 permission. As such, the principle has been accepted. But that's not actually dealing with the point as to whether the substation does or does not form part of this proposal. Unless I've missed something.
Well, it doesn't say that in terms. But given that the very purpose of the application was to allow the original solar park to operate in tandem with the substation that had been permitted in 2021, there was in my submission no real need to go beyond that.
But it would have been nothing wrong with a fresh Section 73 application which did include the substation element.
No, with respect to
indeed, had it done that, we wouldn't be here.
Quite so. For whatever reason, the developer went down this road of seeking to marry the two together. But in our submission, if one looks at the plans and one looks at what is proposed, it's perfectly clear that whatever was permitted in terms of a substation in 2017 and then finalised in 2020, the proposal here superseded that. There was an update report, and that's at tab 19. And at page 275, paragraph 3.6, the officer makes clear the solar farm will be connected to the grid and the existing pylon network through the permitted substation application. And that was the application that the authority had granted permission for the previous year. As I say, my Lord, Mr. Williams will address your Lordships more fully on these points, but in my submission on the documents, it's clear enough what was being proposed. Whatever had been permitted before, it was superseded by the 2021 substation permission, and that was going to connect the solar park to the national grid. My Lords, if I may, I'm going to turn to the statutory framework, so the authorities bundle, tab 1.
Thank you.
Section 55 of the Town and Country Planning Act 1990 defines what is regulated by the Act, that is development. Section 55(1), subject to the following provisions of this section of this Act, except where the context otherwise requires, development means the carrying out of building, engineering, mining or other operations in, on, over or under land, or the making of any material change in the use of any buildings or other land. So operational development or material change in the use. Section 57, subsection 1 states, subject to the following provisions of this section, planning permission is required for the carrying out of any development of land. Section 58 is concerned with the grant of planning permission. It says, planning permission may be granted in a number of ways, and we're concerned with 1B, by the local planning authority, then omitting words, on application to the authority, omitting words, in accordance with a development order. So the trigger for the grant of planning permission by the local authority is a planning application according with a development order. And currently the relevant development order is the Town and Country Planning Development Management Procedure England Order 2015, which is in tab 2, but we won't go to that just yet. The power to grant planning permission is more fully fleshed out in section 70. Section 71 says where an application is made to a local planning authority for planning permission, subject to various provisions, they may grant planning permission either unconditionally or subject to such conditions as they think fit, or they may refuse planning. Plainly, there is a link between the permission that is granted and the application, but the Act does not say that the planning permission must be for the entirety, must mirror the development for which the application is submitted. There must be an application, and it's implicit that the permission granted must relate to the application, but the scope and content of the application is not defined by the Act, it's left to the local planning authority. Forgive me, the permission is defined, yes. The terms of the application are entirely a matter for the applicant, subject to complying with the development order, which lays down various requirements regarding the form and the documents that must accompany it and so on. But the scope of the application, what permission is sought for, that's entirely a matter for the applicant. What is granted by the local planning authority is a matter for the local planning authority. And both the scope of the planning permission and the form of the planning permission are for the local planning authority alone. So in my respectful submission, the statutory scheme does not require the planning permission to be a mirror of the application. The scope and form of planning permission is entirely left to the discretion of the local planning authority, complying with its statutory obligation. What is permitted is subject or can be subject to such conditions as the authority thinks fit. And that is a very broadly expressed power to impose conditions. As the courts have held, it's not an unlimited power, but it is a very broadly expressed power. And it's notable in my submission that it is the permission, the grant, that is subject to the condition. So if there is any conflict between the conditions and the grant, the conditions prevail. At least that's the statutory starting point.
Sorry, could you just say that again?
If there is a conflict between the grant, the words of grant, and the conditions, the statutory starting point is that the conditions prevail.
Is there any authority for that?
My Lord, no, I can't point to one. There is plenty of authority for the proposition that in order to decide what planning permission is for, you need to look at the grant and the conditions. But as to whether there is...
I think what Lord Justice Lindblom said in Barton Park was that it's the operative part which tells you what the permission is for. It's then subject to conditions which regulate the grant. But we can look at that.
And while looking at that point, I think Lord Wolfe said something to the effect that if you grant permission for 50,000 houses and then in a condition say 40,000, then that's going to be an invalid condition.
Because it's inconsistent with the grant.
And therefore that suggests that if there is a hierarchy, you may be right, there's no hierarchy, but but if there is a hierarchy, it's the grant that you look at first.
No doubt one looks at the grant first to see what the permission is for, but to see the scope of the permission, what is actually permitted, you need to look at the conditions as well.
Well, then you might need to deal with the, certainly Aver's dicta of Lord Wolfe about the 40,000 and 50,000 houses.
Well, my lord, I will certainly look to see if we can find that dicta, because that would be...
Yeah, I'm sure it was Lord Wolf, but if I'm wrong, I'm sorry.
To help, I think there is authority which says that when we look at the wording of the conditions as an aid to understanding the grant, but the conditions aren't the dog, they're the tail.
Well, the dog comprises the grant and the conditions.
Well, you will need to show
I will.
authority for that.
Can I take your lordship then very quickly to tab 16, the case of Lambeth, London Borough Council, just on that very point. For present purposes, we don't need to go into the facts. If your lordship would just go to paragraph 9.
That's tab 16.
Tab 16, Lambeth, London Borough Council, tab 16, paragraph 9 of the judgment of Lord Carnwath, where he quotes from what Mr. Justice Sullivan said in Pye, and at the bottom he says, just above letter H, the original planning permission comprises not merely the description of the development in the operative part of the planning permission, but also the conditions subject to which the development was permitted to be carried out.
Yes, that's understood, but it's not saying that the conditions have a greater legal status than the grant. And it's not saying that the grant is contained in the conditions as well as in the operative part.
Well,
I'm just saying you must read the permission as a whole.
Yeah.
I mean, part of the reason for saying that in that case was a Section 73 permission where the decision letters failed to repeat all the material conditions which had been set out in the original permission, which it was, to use common parlance, varying. That was the context.
Well, that was the context, but the observations and they've been said a number of times. What is actually permitted is determined not just by the words of grant, but by the condition. So, returning to section 17 and the breadth of the local authority's power, the scope of the grant of planning permission is for the local authority. And simply as a matter of principle, it can grant permission for less than what is applied for. That would be an essential flexibility in any scheme of planning control. But also the form in which it grants planning permission and the conditions it imposes. They are a matter for its discretion. Section 72 expands on the power to impose conditions. Without prejudice to the generality of section 70, subsection 1, conditions may be imposed on the grant of planning permission under that section. It says, for regulating the development or use of any land under the control of the applicant, requiring the carrying out of works and so on. Or in B, effectively imposing a time limit.
Well, that enables you to impose a condition on land outside the application site, provided the land is within the control of the applicant.
Yes.
Otherwise known as blue land.
My lord, yes.
Yeah. And does anything turn on that in this case?
No.
No.
My lord, the last statutory provision I'm going to take your lordship to is section 73 itself. I just invite your lordships to read subsections 1 and 2. if on receipt of a Section 73 application the local planning authority decides that no change should be made, it simply refuses the application, leaving the original planning permission. If it decides that yes, a modified planning permission should be granted, it can do that subject to different conditions, and it's then for the developer to choose which permission to implement, either the original permission or the Section 73. The power to impose conditions is in my submission as broad as it is under Section 70.
Can I ask a question? Is it clear from the first two lines of subsection 2 that one thing an authority cannot do under Section 73 is to change the operative part of the original permission?
My Lord, yes, I accept that, and that was the ratio of the decision in Finney.
Does it also follow that the local authority cannot impose a new condition which would have the effect of changing the operative part of the original permission?
Well, with respect, my Lord, I would say conditions cannot change the operative part. The operative part remains unchanged. One can impose a condition that modifies the scope or effect of the planning.
So the answer to my question is, on your case, yes.
Yes.
But if that be right, that would negate the first principle, which you and I agreed a moment ago, namely the local authority cannot change the operative part. You're saying, but yes, but they can by way of condition, a new condition.
My Lord, it may be a terminological difference. If one accepts that the effect of a planning permission is determined by the words of grant and the conditions, then by changing the conditions, inevitably you change the effect of the permission.
Thank you.
And it has been accepted for some years that one can change the scope of a permission by condition.
Well, certainly, if you're a local planning authority granting permission for something different from that which was applied for.
Yes, and my Lord, it can do that in a number of ways. It can change the description of the proposal, or it can leave the description unchanged, but impose conditions that modify what is sought. My Lord, the form and content of a planning application, as I indicated, is governed by a development order, and that's at tab 2. I'm not going to take your lordships to the details of that. There are some provisions that also refer to decision notices issued by local planning authorities, what they should contain. But there is nothing in the order that says how a local authority should structure its decision notices, how it should express the grant of planning permission. The only restrictions on that, or the only obligations on that, are in Article 35 of the order. Perhaps I ought to look at that briefly. Tab 2, page 66 of the bundle. Uh, 35.1, when the local planning authority gives notice of a decision or determination on an application for planning permission or for approval of reserved matters, certain information must be included, and then at 1A below, where planning permission is granted subject to conditions, the notice must state clearly and precisely their full reasons for each condition imposed, and in the case of each pre-commencement condition, for the condition being a pre-commencement condition. So local authorities have to explain why they impose conditions, but that's the extent of the obligation when it comes to the form of a planning permission. So how it expresses the grant What conditions it imposes, that's left to the local planning authority. And in my respectful submission, there's nothing in the statutory scheme, under the Act or the order, that says you cannot impose conditions that have the effect of cutting down what is set out in the words of grant. There's nothing in the statutory scheme that says you cannot do that. It may not be elegant, but there's nothing that says you cannot grant permission for 10 houses, but impose a condition saying that only 9 shall in fact be constructed. That, in my submission, would be in accordance with the scheme.
Might be said to be irrational,
Oh.
and therefore ultra-virus.
Well, it depends why.
Well,
A scheme of development...
blatant inconsistency.
Well, a developer applies, the application is for the construction of 10 houses. That's the proposal, and the local authority adopts that proposal in its consultation.
But only wants to approve 9.
Only wants to...
Well, the alternative is for them to grant permission for 9, and that would be rather more sensible, wouldn't it?
Well, yes.
Even in the world of planning.
Well, that may be more, but local authorities have for years been granting permissions in all sorts of ways, and while that is certainly the neater option, in my submission the alternative, keeping the proposal that the applicant has put forward for consultation purposes and so on, but imposing a condition at the end of the process, that is a lawful alternative way of going about it.
Can I just put this to you? You're quite right, the local authority, it is for the local authority to decide. They've just got to operate lawfully. And if someone says, I'm going to grant you planning permission for 10 on page 1, and then on page 2 says, actually, I'm only giving you 9, you might think that the person who's written the letter is an idiot. And the exercise of statutory powers is not lawfully granted. I mean, it may be that there's a perfectly sensible explanation for it all, but it's not obvious.
Well, the reason it comes about in my submission is this. Local authorities, by and large, take the description of the development from the application form. And that's what happened in this case. One looked at the original application form for the 2017 planning permission. It's the same description of development. Because that is the proposal, that's the applicant's proposal, and that's what they consult on. They may conclude at the end of the process, actually, some of this development is not acceptable. Application for 10 houses, 1 affects a listed building, so that's unacceptable, but 9 would be acceptable. How does it go about granting the permission? It could modify the words of grant, or it could grant a condition saying, notwithstanding what we say in the words of grant, we're going to permit only 9 houses.
But in that situation, the words of grant are not effective. They have no legal effect other than to permit up to 9.
What?
When read with the condition. I mean, I was thinking a moment ago, well, you could theoretically have a situation where the local authority, taking your example, wants to grant permission only for 9, but says, we'll grant permission for 10, but then condition it, leaving open the possibility of a Section 73 application subsequently, which changes the condition from 9 to 10. But in fact, thinking that one through, if that were to happen in those rather odd circumstances, you'd end up with a fresh permission anyway. So you might just as well have... in fact, you couldn't even do... Well, yes, you could do that, but yeah. Thank
My
you.
Lord, stepping back, all conditions, in effect, regulate, restrain, qualify what would otherwise be an unqualified grant. If you grant permission for 10 houses and impose no conditions, you can build whatever houses you like, as long as there are 10 of them.
Or up to 10. You
Or
could
up
build-
to 10,
yeah.
yes, absolutely. One doesn't have to build out development.
No.
But an unqualified grant like that is different from a grant that is subject to conditions that may regulate the materials and the location and so on. So all conditions, to an extent, modify an unqualified grant.
But taking your example, say the local authority grants permission in the operative part for 10 and then has a condition that says you can only build one. Isn't that going back to my Lord's phrase earlier on, taking away with one hand what you're granting?
I entirely accept that one can have a situation where the conditions imposed are ridiculous. An obvious example, planning permission is granted for the construction of a dwelling house, but a condition is imposed saying it cannot be lived in. That would be a truly irrational grant of planning permission. Well, that's very different from a planning permission granted for the construction of 10 houses.
That's going against a statutory provision in the Act, which says that the building you approve can be used for the purposes for which it's designed. You're actually conditioning away that effect of the statute.
Well, yes, I'm not sure if that provision prevents the imposition of conditions generally, but I mean, that's an example. A condition attached to a factory permission that says the factory can operate only between midnight and 1 in the morning. I mean, it's not difficult to imagine conditions that render the permission an absurd or pointless permission. But that's very different, my lord, from this case. Planning permission granted for a solar park with all sorts of ancillary elements, one of which is a substation. Why can it not remove that by way of condition? There is nothing in my respectful submission remotely irrational about what the local authority has done here.
Particularly, I suppose, you say, in circumstances where everyone knew that the substation had been approved.
Yeah.
But the effect of what you're submitting is that back in 2017, you're saying the local authority, when it granted the original permission, could have granted it the operative part, including the substation, but a condition actually could have been imposed saying there should be no substation.
Yeah. Yes.
That's the effect of your submission.
It is, and one would need to know why that was done in order to decide whether that was lawful or not. If it was done because the local authority didn't want this solar park to work, and it was prepared to permit a white elephant that was never going to connect to the grid, well, that would be truly irrational, and the condition would be struck down for being unreasonable. But if it granted permission for the solar park without a substation because it knew that 6 months, 12 months down the line, the developer was going to come back with an application for a separate substation permission, well, that may make perfect sense.
I mean, the case you cite, which is said to be an example of this, is Stevens.
It is. And we can go to that straight away, because that is a helpful illustration of the power that exists in my submission. It's tab 12. A decision of Mrs. Justice Patterson, and one can see at paragraph 6 the relevant planning permission is set out.
Well, that's the grant.
That's the grant, the words of grant.
And it included in the last couple of lines excavation of a cable trench to the south for grid connection,
Yeah.
etc.
That was subject to conditions, and condition 20, a few lines below, the southern cabling route from the main site to Aberbeek does not form part of this planning permission.
So, condition 20 took away in that hand what had been
Yeah.
granted in the grant.
Yes, it took away a modest part, an ancillary
I find this a very difficult decision to follow at the moment, and as far as I can see, it's not been cited subsequently, save by Mr. Justice Morris in this case.
No.
But when you go to the grounds of challenge at paragraph 7 on page 152, this issue seems to be tackled under ground 1. The planning permission is unclear and Wednesbury unreasonable.
Yes.
On its face, as it does not grant planning permission for the excavation of the cabling trench route to the south. So that was the ground of challenge, not that as a matter of law there is no power to have a condition which takes away from it was a clarity point, and the point of clarity arose because the ecology officer in the case was expressing concerns about a lack of assessment of that cabling route, and it was going to require further study and reports.
Yeah.
That's what the case was about.
Well, yes. At paragraph 36, the substance of the challenge is set out.
Is it unclear in its face? And Mrs.
Yes.
Justice Patterson said, no, it's not unclear. Linguistically, you can understand what it means.
Yes.
But I don't think she actually went on to, she wasn't asked to deal with the viries, was she? In the sense of whether you can have a condition inconsistent with the grant of permission.
Well, we have the report, we can see what arguments were advanced.
Well, I may have missed it, sorry.
Well, no, it's paragraph 36 that sets out the substance of the challenge to that condition, and paragraph 41 is Mrs. Justice Patterson's response to it. But part of the argument was whether you're giving with one hand and taking away with the other.
I suppose the last sentence of 36, you get closest to it, the effect could be to prevent the planning permission from being implemented.
Yeah.
Well, that sounds like a practical effect, that you won't be able to operate it unless you've got a connection.
Well, yes, and they would need to come back for a further planning permission for that particular
That's a slightly
connection.
different.
Well, with respect, my lord, this is a perfectly intelligible response based on well-recognised practice. You can cut down the permission by imposing a condition.
Yes, but as you accepted earlier on, the more straightforward way of doing this is to actually reflect that in the grant itself,
Yes.
rather than go around the houses.
Well, yes, although local authorities, having consulted on the proposal as put forward by the applicant, may choose to leave the proposal description in place and just deal with the matter by way of condition. In my opinion, that's a perfectly proper way to go about it.
But is there any legal advantage in doing it that way, the second way?
It may evolve arguments about consultation and so on. If you change the description of the proposal at the end of the process, objectors might say, well, hang on, that's not what you consulted.
I'm not following this. You're referring to the Bernard Wheatcroft line of authority. Going back to your proposition that the local authority can grant permission for less than is sought,
Yes.
established, one consideration which affects whether it's appropriate to do that is the effect on public consultation. If it were to be concluded that a change is too great to respect the requirements of public consultation, the answer would be, well, you can't cut down the scope of the permission by changing the grant, correct?
That would be an argument.
Yes, but you couldn't get around that conclusion by saying, well, I'll do it instead by imposing a condition which cuts down the grant.
Well, it might be said, having consulted, for example, on a scheme of 10 houses, there's no harm in imposing a condition just refuses.
Yes, but that's an example, forgive me,
Yeah.
that's an example where there's no consultation problem. My question arises where there is a consultation problem. If there is, then you can't get around it by dealing with the matter by way of condition instead of fiddling around with the grant.
Well, My lord, I do understand that there is a simple approach, amending the terms of grant, and there is the more convoluted approach of imposing a condition. The question is whether the convoluted approach is nonetheless a lawful approach, and in my submission, if one looks at the authorities, it has been accepted as a lawful approach for some time. In that vein, can we go to the first of the authorities in the bundle, at tab 4? The case of Kent County Council, and that was, the development in question was an oil refinery, and over the page, at page 71 one can see that the local planning authority had refused planning permission for an oil refinery. The applicant appealed to the Secretary of State. The inspector had recommended, this is 3 lines down, page 71, an inquiry was...
84.
Forgive me, my lord, there are 2 sets of numbering. There's the internal case report number, and at the bottom right there's the bundle number.
Right, I beg your pardon.
Forgive me, no, it is confusing, my lord. I've confused myself on occasions. Page 71 of the report, or 79 bottom. So part of the head note.
And it was how many lines down?
3 lines down, an inquiry was held, and the inspector recommended on environmental grounds, and because of the inadequacy of the surrounding road network to take the traffic involved, that the application be refused. Secretary of State, however, decided that it was in the national interest that the additional refinery capacity should be made available. He recognised that the road system was inadequate and said that he had in mind to refuse permission for the construction of the access road as proposed, and to grant outline permission for the refinery, a jetty, rail terminal facilities, and the pipelines between the refinery and the terminal, subject to condition, amongst other things, that saviours should be agreed from time to time with the local planning authority or in default of agreement determined by himself. No deliveries of oil or oil products or byproducts should be made to or from the refinery or terminal except by sea, pipeline or rail transport. And ultimately, 10 lines down or so, we can see that the inquiry was reopened in April 1975, and on December the 31st, 1975, the Secretary of State for the Environment granted permission on the lines which he had previously indicated subject to certain further conditions. And that was challenged, and one of the grounds of challenge, again 7 or 8 lines down, 3, that the condition imposed by the Secretary of State was invalid because it was unworkable and because it took away a substantial part of the benefit of the planning permission.
He granted an outline planning permission, but refused to accept the particular proposal for a form of access.
Yes.
Grant of the outline planning permission for the oil refinery carried with it an implicit permission for some form of access.
Yes.
So this is not an example of a condition inconsistent with the grant.
Well, no, we don't have the words of grant in this case.
But logically that would follow.
Yes, logically that would follow. The challenge to the condition is dealt with ultimately at page, it's 79 of the report, 87 of the bundle. And one can see further way down, invalidity of condition. The applicants say that condition 5, the condition which requires that the delivery should be made only by sea, pipeline or rail transport, is invalid, first because it's unworkable and secondly because it takes away a substantial part of the benefit of the planning permission. And then jumping 7 or 8 lines, as to the second point, a conditional permission is almost invariably less beneficial than an unconditional permission. It must always be a question of fact and degree whether a particular condition is such as to take away the substance of the permission, in which event that condition may be invalid. In this case, however, the development sought is the construction of an oil refinery and all else is ancillary to that purpose. Of course, if the condition had been such as to render the oil refinery unworkable, that would be a different case, but the second respondent's acceptance of the condition is evidence that it's certainly not this case. And in my submission, those observations have parallel to the present case. The substation was very much an ancillary element of the solar park. And by removing it, one was not removing the substance of the solar park permission.
So a bit like the CCTV cameras.
My lord, yes. Now, my lord, I entirely accept as we don't have the words of grant, we can't say whether or not there was any express conflict in wording between the condition and the grant, but the principle in my submission holds good. It's possible for a local authority to cut down an application proposal by condition, so long as it's not removing entirely the benefit of the permission. The next case is Wheatcroft, and that's the one that's most often cited.
Does that legal proposition, just before you go to Wheatcroft, does that legal proposition get affected by the fact that in this case we know that the substation's going to be built under a different condition?
Well, yes, that is a relevant consideration, because one needs to understand why a condition is imposed, and is its effect going to be to render the permission unworkable? Well, we know that's not this case, because we know that the solar park is to operate in tandem with a separate substation, or rather a separate substation permission.
And this is all, I mean, these principles you should not give with one hand and take away with another. And those are all just public law principles.
Yeah.
And the statute itself doesn't really help us beyond what you've taken us.
No.
So it's just a matter of carefully analysing these authorities.
Well, yes, and a question of fact and degree. Because one might have a condition that removes an element that in one case is unacceptable and in another entirely understandable.
Thank you.
My Lord, Wheatcroft is behind tab 5. Again, this arose from an appeal to an inspector. One can see, and perhaps your lordships could simply read the headnote to see what the facts were. In that case on appeal, the Secretary of State had decided that he could not, as a matter of law, reduce the scope of the application or appeal proposal by the imposition of a condition, and that was held to be wrong by Mr. Justice Forbes. I suppose the critical part of the judgment is at page 239 of the report, page 95 of the bundle. About 10 lines down, there is a sentence beginning, both I think accept as a starting point. And perhaps your lordship could read from that sentence to the end of the paragraph. My Lord, the judgment continues to page 241 of the report, where the test is expressed again. It's the bottom half of page 241. First, Ms Justice Forbes concludes that the relevant test, whether a condition is permissible or not, to cut down the scope of development is not whether the application is severable. In the passage I conclude for my part, he rejects the proposition that one can only cut down development where it's severable, and he says, I should add a rider, the true test is, I feel sure, that accepted by both counsel, is the effect of the conditional planning permission to allow development that is in substance not that which was applied for. And that, in my submission, is the true test. One can impose a condition cutting down the scope of the grant, provided you're not effecting a substantial alteration to the proposal.
That applied for. It's not a case dealing with an allegation of internal inconsistency, between the grant and the condition.
I accept that. This was a case that where there was no decision notice. There was a refusal to grant one.
And what do you say to the respondent's, short point, which is, okay, on that test, and reading it, is the effect of the conditional planning permission to allow a development which is not that which applied for. The planning development was for a solar farm and a substation, and you've now taken that away.
The permission the permission that was granted omits one element, the substation, because there is already permission for a substation that's going to work in tandem. In those circumstances, in my submission, there is no substantial alteration.
Of what?
Of the original proposal.
Proposal or permission?
Either.
It's the latter which is the true legal question, isn't it? This is a Section 73 application.
It is, my lord. But under Section 73 you can impose the same conditions you could impose on the original planning permission. And so if on the original planning permission you can impose conditions that cut down the scope of the proposal, one can do the same thing at the Section 73 stage.
But in 2000, part of your reasoning, I know this is quite technical, but part of your reasoning was, well, you could do this in 2021, 22, whenever, because there was a grant of planning permission in 21 for the other substation, but that hadn't happened in 2017.
Well, factually, yes, that's absolutely right. But the power needs to be exercised at the time of the Section 73 application, and you have to take account of all the circumstances at that stage.
I mean, basically, in simple terms, going back to 2017, if the local authority had granted a planning permission for solar farm with substation, but then imposed a condition saying there will not be a substation, you say that's lawful.
So long as there's
you have to say that to make this argument work in relation to the 2022 permission.
I say it's within the powers of the authority. Yes, it's lawful, provided it's done for a proper reason. I fully accept if the local authority imposes that condition simply to stop the development going ahead.
Well, that's an improper motive.
Well, absolutely. So it's not good enough.
But absent some improper reason, you say it's lawful to have that inconsistency on the face of a permission.
Yes, because the grant is always subject to whatever conditions are imposed.
As long as the condition, for example, said, we've taken away permission because we know that this is needs to be discussed and a further application for full planning permission will be made in the coming time.
Well, that would be ideal.
Of course, nowadays we also have in the legislation, I've not actually seen an example of this yet, permissions in principle.
Yes.
I mean, you don't necessarily have to have an outline planning commission. You can have a decision that the principle of the development is acceptable.
But I suppose your short point is that this would be taking a good principle of law and applying it to a ridiculous situation where the substation has been granted permission.
Yeah.
And coming out with, therefore, the wrong legal result.
Well, yes. First off, is there the power to do it at all? And we say, looking both a statutory scheme and authority, yes, you can do it. Is there a good reason to do it in this case? Yes. And the case of Stevens is, in our submission, a perfectly unexceptional application of the principle.
Where in that case, it was taken away by the condition because they hadn't yet worked out a proper lawful way of doing it which complied with the environment.
Yeah. And in the present case, the substation that was omitted was one that wasn't going to work anyway, not on its own. It was just a 33 kilovolt substation. You need the other element for it to work. And so its omission, when you've granted permission subsequently for a substation that does work, its omission is perfectly sensible.
And the Stevens case is really odd because there were two options available for connecting to the grid, and the developer wasn't necessarily committed to that which was excluded by condition and referred to in the grant. So there was no need to refer to the southern route in the grant at all. It was gratuitous.
Well,
it's a very strange authority.
It's up to developers how they describe their development.
Well, it's up to the planning authority to decide how to describe it in the permission,
My lord,
so as not to confuse the public.
Absolutely, my lord. But that then leads it to interpretation rather than violence. In my submission, there is power to impose a condition that cuts down the scope of the grant. The question is whether it was lawfully exercised in this case.
I'm slightly conscious of time and the fact that you've got Mr. Williams to follow you, as well as we've got to give enough time for Mr. Burton to respond to all these points.
Well, yeah. The problem is there is quite a lot of case law to go through.
Fine, keep going.
The next one then, Arrowcroft. Tab 8. And that was, that concerned a Section 73 application. Going straight into the judgment of Mr. Justice Sullivan, it concerned a challenge to a resolution to grant a Section 73 permission. So again, there is no actual Section 73 planning permission in place, but it's still highly relevant. If one goes to page 115 of the report, paragraph 6, just for the facts, outline planning permission granted in 1999. Under the description of development, the notice of planning permission said, and your lordship will see the words of grant over the page, it included one variety superstore. So outline planning permission for mixed development, including one variety superstore. And there are conditions imposed relating to that. Then going on to paragraph 12 of the report. A Section 73 application was made in 1999. There were going to be changes in the users of the occupiers of the development. And at paragraph 13, you have the application that was made. It's sort of variation of the conditions attached to the previous permission. And your lordship will see the buildings to be erected shall comprise B, a food superstore and non-food variety stores. And then condition 17, the non-food variety stores shall at no time exceed 6 in number. And as Mr Justice Sullivan then said at paragraph 14, in a nutshell, the applicants in these proceedings are concerned that substituting up to 6 non-food, that's to say comparison stores for the one variety superstore, which was permitted in 1999, had an adverse retail impact on Coventry city centre. Paragraph 23, Mr Purchase QC on behalf of the applicant accept, albeit with some reservation, the factual position which is set out above. He submits the local planning authority simply had no power as a matter of law to grant a new planning permission under section 73 incorporating the different conditions which I have set out above, because those altered conditions introduce a fundamental inconsistency between the conditions and the description of the development contained in the notice of permission. And my lord, I would stress the word fundamental. Fundamental. Mr Justice Sullivan's conclusions appear at paragraphs 29 onwards, and he starts by referring to the planning encyclopedia. He says that he considers the approach in paragraph 7206 of the encyclopedia is a useful starting point. It's as follows. A condition may have the effect of modifying the development proposed by the application, provided that it does not constitute a fundamental alteration in the proposal. And that, in my submission, is Wheatcroft. A number of cases are then cited, in which was decided that various conditions requiring, etc., had not constituted fundamental alterations in the proposals that were being placed before the planning authority. The passage continues similarly, a condition may scale down the applicant's proposals. Permission may be granted in a suitable case for part only of the development for which approval is sought, or in respect of part only of the land to which the application relates. And my lord, Mr Justice Sullivan is drawing inspiration from established case law that says one can impose conditions and cut down the scope of development. And the critical paragraphs are paragraphs 32 to 35 of the judgment. Can I ask your lordships to read those paragraphs? My lord, Mr Justice Solomon described the inconsistency between the proposed condition and the words of grant as a fundamental inconsistency, or as amounting to a fundamental alteration. That's at paragraphs 30, well, at paragraph 33. If the true legal test, as Mr Justice Morris held, was any inconsistency is unlawful, the judgment would have been much shorter, because the inconsistency in wording is on. What Mr Justice Sullivan was doing in my submission was simply applying the case law established in Wheatcroft, that so long as you are not substantially altering the proposal, you can impose a condition.
Well, you just said it. In Wheatcroft, the test was not fundamental, it was substantial.
Forgive me.
And with a view to consultation requirements. It's not the same test. That begs the question, doesn't it? Is the judge here laying down the test or expressing a factor in that case, which was a fortiori?
On the facts, my lord, it was a fortiori. He described it as a fundamental inconsistency.
Well, it plainly was.
Yes.
But that doesn't necessarily mean he was describing, in legal terms, the boundary of the power.
My lord, I accept substantial alteration is the test. And in this case, the facts were even starker, hence the language used. But, my lord, there would have been absolutely no point in Mr. Justice Sullivan referring to that earlier case law if he was in fact going to apply a different test.
So does it follow from what your analysis that if Wheatcroft is to be read into Section 73, delimiting it, then the fallback, the second restriction, should not be expressed in terms of fundamental alteration, but substantial alteration?
Well, yes.
Yeah, okay. If there is a second restriction.
If there is. Yes, if the word fundamental has slipped into my language, I apologise. It's substantial alteration, that's the test. It's just that in this case, Mr. Justice Sullivan expressed himself in forthright terms.
Yes, indeed.
On the facts. But, my lord, this was, in my respectful submission, plainly an application of the Wheatcroft principle. Otherwise, why else refer to the case?
Well, he described it as the starting point.
Yes. But if that isn't, if mere inconsistency itself is enough, this judgment could have been half a length. My lord, I'm going to go to two more authorities, if I may, briefly. The next one in the bundle, tab 9, is Cadogan. And I refer to it only because it's relied on subsequently in the case of Finney. Cadogan was not a case of inconsistent grants and conditions. It was instead a case where planning permission was granted for mineral extraction and a condition was imposed requiring a remediation scheme to be submitted and approved and carried out. And that condition was challenged on the basis that potentially it allowed the developer to come forward with entirely different remediation proposals than had been before the authority when it granted permission.
Well, the particular point was that he could come forward and get permission for remediation, which involved bringing materials onto the site rather than all the remediation being from the use of materials on site.
Well, yes.
So it went to the scope of the permission.
Yes, well, it certainly went to the scope of the condition,
Yeah.
which had to be interpreted. To understand the facts, page 411 of the report, 120 of the bundle, Lord Justice Glidewell begins, pioneer aggregates applied for planning permission for the extraction and processing of sand and gravel from 90.5 hectares of land. Planning permission was refused from that, and at page 412 there is a paragraph a third of the way down. The Secretary of State gave his decision in a letter. He accepted his inspector's recommendations, allowed the appeal and granted permission subject to conditions. Then, skipping a paragraph, before both the judge and this court, Mr. Cadogan's challenge to the Secretary of State's decision was and is based on two grounds. It's only the first one that's relevant. The Secretary of State has no power to impose condition number 37 in relation to the restoration and after use of the land. At the bottom of the page, the paragraph beginning the restoration scheme provided Would your lordships read that paragraph to see what the restoration scheme was? So the site was to be restored with, among other things, lakes. And the condition that was opposed that prompted the challenge is the middle of page 413, ground 1. And that required that the supply of water be tested. And it was the last sentence, if the sufficiency of the water supply cannot be demonstrated to the satisfaction of the Mineral Planning Authority, then an alternative restoration scheme shall be submitted to and agreed by the Mineral Planning Authority. And that was what caused concern. And then it's the next sentence that is relied on in Finney. It is established law that a condition on a planning permission will not be valid if it alters the extent or indeed the nature of the development permitted.
And you accept that as an accurate statement of the law?
With respect, no. The source of that proposition is not made clear at all. But the two authorities cited in that case don't bear on it. At page 411 of the report, Westminster City Council, that concerned a challenge to a development plan, and Wilton and West Sussex Council, that concerned a planning permission modification order.
Well, it might have come from nowhere, but it is in the judgment of the Court of Appeal,
Of course it is.
with which the three judges, including Lord Bingham, agreed.
Well, of course it is.
So if you don't accept it as right, you then have to get into Bristol and Young Aeroplanes and all the rest of it to...
Well, it depends what is meant by nature, as in the nature of the development permitted. If it meant one cannot affect at all the scope of a permission by condition, one would not impose any conditions at all, because all conditions, by definition, regulate, qualify the words of grant. The present case is a good example. There's a condition that requires that after 25 years, the development is removed. That's typical for solar parks. The land is meant to be restored after 25 years. So it's a temporary permission. And that condition fundamentally restricts the scope of the development to a 25-year timescale. Without it, this would be permanent development. So that's a condition that in my submission plainly affects the scope or extent of the permission, but no one suggests that it's unlawful. Indeed, section 72 makes clear that that sort of condition is lawful.
Yeah, but for solar parks, the development permitted is you can have it for 25 years.
Yes, but the 25 years is imposed by condition. Without it, the solar park would be forever.
Yes, but there's nothing in the grant which says this is an unlimited time, unlimited permission. There's no inconsistency internally in the decision.
Well, this is a different point. This isn't about internal inconsistency. This is about whether you can impose a condition that alters the extent or nature of the development permitted. Now, it was looking, I suspect, to the future, because the concern of the objector was that the condition itself might allow some years down the line, a different remediation scheme to come forward.
Well, involving bringing material on
Yes,
site. It was
yes.
a huge scheme.
Yes, absolutely.
And one bears in mind what Lord Justice Gleibel said at report page 411, first paragraph of his judgment. He describes the grant, the implicit grant, on the application form. The proposal for the restoration of the land was described as, and it says, progressive restoration using on-site materials. And that was an inherent feature of the grant.
Well, yes, and the condition was imposed as, in effect, respecting that. It was held ultimately that the condition did not allow a fundamentally different remediation scheme to come forward. So it was held by...
The ratio effective is you should construe the condition as being compatible with the grant.
Well, he was construed as compatible on the facts of this case. Yeah.
But he said, I think, that the only schemes that could come forward and be approved under the condition were those which would not involve off-site material,
Yeah.
effectively. Yeah.
So, no finding actually that the principle expressed at page 413 was contradicted or breached.
But is there, going back to my Lord's question a moment ago, is there an authority which suggests that this was decided per incuriam?
Well, no, but one has to put the proposition in context. It was concerned with a condition that was thought in the future might allow a different remediation, an entirely, fundamentally different remediation scheme. And so to that extent, I accept what is said there, that you can't have a condition that at some point in the future allows a fundamental, forgive me, a substantially altered scheme of development. And insofar as what is said there is perhaps simply a different way of putting the substantial alteration point, then I would accept it's entirely correct. So perhaps, in answer to my Lord Justice Dingemans' question, do I say that's wrong? That depends on how one interprets it.
But okay, if it's a substantial alteration.
Yes.
And consistent with a long line of authority.
Yeah.
Yeah. Okay.
And my Lord, Lord Justice Glidewell had himself been in the case. It's I think at
Yeah.
well, I've referred to it,
Yeah.
where Wheatcroft had been accepted as correct. So he.
It's the RHA case.
Yes.
You had one more authority.
My Lord, yes, and the case of Finney,
Thank you.
which is at tab 17 of the one. Paragraphs 2 and 3 of the report, Lord Justice Lewison sets out the facts. An application for planning permission was granted. The proposal or the development described is in paragraph 2. It's essentially a 100-metre tip height wind turbine development. 2 wind turbines with a tip height of up to 100 metres. That was the proposal. And then at paragraph 3 he says that the council granted full planning permission for the development proposed by you as shown on the application form, plans and supporting documents. So planning permission was granted for 2 wind turbines with a tip height of up to 100 metres. That was the original permission. Paragraph 4, he records that then a few months later, the applicant applied under section 73 for the removal or variation of condition 2 of the planning permission, which was a plans condition. And why? Because it wanted to construct a taller wind turbine. Paragraph 6, the application was supported by figure 318. It made clear that the applicant was seeking the variation so as to permit tip heights for the turbines of up to 125 metres. That was refused, went to appeal, the inspector allowed the appeal. Paragraph 8, in a careful decision letter, she rejected all the grounds of objection. She said the appeal is allowed and planning permission is granted for installation and 25-year operation of 2 wind turbines and associated infrastructure, and then omitting some words, without compliance with condition number 2 previously imposed on the earlier planning permission, subject to the conditions set out in the schedule attached to this decision. And then at 9, those conditions included condition 2, which required that the permitted development should be carried out in accordance with plans which included figure 3.1a. The turbine showed on those plans was 125 metres high. It will be immediately apparent that in the description of the permitted development, the words with a tip height of up to 100 metres contained in the original grant have been excised. So the words of grant in the original permission had referred to 100 metre tip height. The section 73 planning permission didn't. And the ground of challenge at paragraph 10, the sole challenge is that she, the inspector, had no power to allow the appeal and to grant planning permission for development that was not covered by the description of the development in the body of the original planning permission. At paragraph 15, Lord Justice Lewison set out what he said were uncontroversial points. And 1 and 2 are uncontroversial. 1, what you have to have regard to under section 73, and it says you have regard to the development plan and any other material considerations. 2, last sentence of 2, any new condition must be one which the planning authority could lawfully have imposed on the original grant of planning permission. Well, that is Arrowcroft. That is what Mr. Justice Sullivan said in Arrowcroft, at paragraph 33. And 3, a condition on a planning permission will not be valid if it alters the extent or the nature of the development permitted. That comes from Cadogan. He then quotes, or Justice Lewison then quotes from the case of Pye, and it's a proposition that we've seen elsewhere. The original planning permission comprises not merely the description of the development in the operative part of the planning permission, in this case, the direction of the dwelling, but also the conditions subject to which that development was permitted to be carried out. And at 21, again, the issue, the single issue in that appeal, the question in this appeal is whether on an application under section 73 it's open to the local planning authority on appeal of the Welsh Ministries to alter the description of the development contained in the operative part of the planning permission. And for the reasons given in paragraph 42, Lord Justice Lewison held that it was not open to a decision maker to do that. And that was a straightforward matter of statutory construction.
And what do you say about those dicta?
Well, I entirely accept paragraph 42. I accept that this is, in my submission, this is the ratio that on a section 73 application, it's not open to the local planning authority to alter the words of grant that appeared in the original permission. I accept that. But that doesn't tell us, my lord, what it can do with the conditions. Plainly, section 73 allows for the imposition of different conditions, and the only limit is they must be conditions that could have been imposed on the original.
But are you saying it remains open to a planning authority to impose a condition which has the effect of removing something from the grant.
Yeah. If that could have been done on the original permission, then it can be done on the Section 74. And you can do that.
Albeit Parliament has said the only thing you could consider in a Section 73 application, unlike a Section 70 application, are the conditions, not the development which has previously been permitted.
Yes, my lord, but returning to, I'm afraid I'm like a broken record. The permission, what is permitted, is defined by the words of grant and the conditions.
Well, that, I appreciate that.
Necessarily, by changing the conditions, you change what is permitted.
But if you're right, it negates the first principle. It becomes nugatory. There's nothing left of it. Doesn't matter that you... It wouldn't have mattered in that case if the inspector had copied out the development as originally described, including 100 metres, and then imposed a condition saying 125 on your argument.
Well, my lord, it would have mattered.
It's an inconsistency which legally doesn't matter.
Well, it does matter if it results in a substantial alteration of the development. So there is that limit. There is always that limit. You can't impose conditions that substantially alter what is proposed.
The other aspect I'd like to ask you about on Finney, because it seems to be important, is that the judge, the Court of Appeal, was reacting to what the judge at first instance had done. And that is made clear. The judge at first instance was Mr. Justice Wynne Williams, and he had followed Mr. Justice Singh, as he then was, in wet finishing works. And those two judgments applied a fundamental alteration test.
Those two judgments apply Arrowcroft,
Yes.
which itself applies Wheatcroft.
Yes.
Yes, the phraseology, fundamental alteration.
Well, whether it be fundamental or substantial or not, Mr. Justice Wynne Williams rejected the argument which was put forward that inconsistency is fatal.
Yes.
He said it had to be a fundamental alteration. The inspector there was entitled to decide it was a fundamental alteration. Application to quash dismissed. It was that which was reversed by the Court of Appeal.
Well, it was.
That's part of the ratio then, isn't it?
The ratio of my submission is simply what appears in paragraph.
Well, if I followed you correctly, to make sure I do understand this, you can find the ratio to the fact that the inspector took 100 metres out of the description of development.
Yes. And that was not lawful. In Finney, Lord Justice Lewison at paragraphs 22 to 29, he analyses Arrowcroft. And Arrowcroft was plainly influential in Lord Justice Lewison's reasoning, as it had been in the reasoning of Sir Wynne Williams and Mr. Justice Singh. And he sets out, at paragraphs 22 to 28, various passages from Arrowcroft, passages that your lordships have already read, but it's notable that he doesn't set out the earlier passages of Mr. Justice Sullivan's judgment, where Mr. Justice Sullivan refers to the earlier case law in my submission based on Wheatcroft. Instead of paragraphs 27 and 28, Lord Justice Lewison goes to paras 33 and 35 of what Mr. Justice Sullivan said. And then at paragraph 29, he says, clear that what Mr. Justice Sullivan meant by the operative part of the Planning Commission was the description of development rather than the conditions. I accept that. These two passages are, in my judgment, dealing with different things. The first deals with the imposition of conditions on the grant of planning permission. The second deals with a conflict between the operative part of the planning permission and the conditions attached to it. So he's...
Sorry, which paragraph is that again?
Paragraph 29.
Yeah, thank you.
He's referring to two passages from the judgment of Mr. Justice Sullivan. And he derives two different principles from those, two different aspects from those passages.
Thank you.
And in my respectful submission, that is not a correct analysis of what Mr Justice Sullivan was doing. In paragraph 33 and paragraph 35, he was simply setting out the law and then applying it to the facts of the case before him. And Mr Justice Sullivan was not seeking to put forward this idea that any conflict between condition and words of grant is fatal. That's not what Mr Justice Sullivan did in my submission.
Could I just ask you to look at paragraph 41 of Lord Justice Lewison's judgment on page 464 of the report? Counsel for the Secretary of State and for the developer supported their submissions by reference to Bernard Wheatcroft, and then he goes into that. And at the end of 41 says he doesn't consider the Wheatcroft test is the right criterion to apply to section 73. Isn't that binding on us?
In my respectful submission, no, because Finney is concerned with the words of grant. Wheatcroft is concerned with the scope of the imposition of conditions. Well, we do deal with this in our skeleton argument, but just above that, at letter D, page 464 of the report, Lord Justice Lewison sets out essentially 4 points why he says Wheatcroft is not the guide, is not the test. The first is that it was not concerned with a statutory provision such as section 73, which expressly restricts that which a planning authority may consider. And in my respectful submission, that goes nowhere, because under section 73, what you are considering is conditions, and Wheatcroft is concerned with conditions. Second, it was concerned with an ongoing application rather than with a granted planning permission which gave rise to legal rights to carry out development. Well, Lord, as I understand it, that is saying, well, under section 73, you have an extant permission already. And that somehow restricts or limits what you can do under section 73. My Lord, I simply don't understand that with respect. The granted planning permission is unaffected by a subsequent section 73 application. The legal rights to carry out development under the original permission are entirely unaffected by a section 73 application that results, or might result, in a separate permission. Well, I with respect, don't understand the point being made there, or why that's an obstacle. Third, it was concerned with a reduction of the permitted development, not an increase in the permitted development. And my Lord, I do understand that it's much harder to accept that one can, by condition, expand the scope of a planning permission than cut it down. At least if you're cutting down, you're not introducing anything that wasn't already consulted on, that wasn't already part and parcel of the application. But if you expand it, it might be said you're introducing new elements going beyond the parameters of the application itself. But of course, the present case is a case of cutting down, not expanding. I should just make clear that there is an authority, it's in the bundle, wet finishing works, where in fact Mr. Justice Singh held that one could impose a condition that had the effect of expanding the scope of the permission. But I'm not going to go to that. Because ours is not a case of expansion, it's a case of reduction. And the final point against Wheatcroft, to ask whether something is in substance the same as something else is a different test from whether something is a fundamental alteration. I do not consider that the so-called Wheatcroft test is the right criteria. But, my Lord, in my submission, one is simply using different phrases to describe essentially the same principle, which is that a condition cannot substantially alter or fundamentally alter a permission. A condition cannot change the nature. By nature, I mean something substantial. So, planning permission is sought for 10 houses. You grant permission for 10, but a condition says one of them can't be built. That doesn't change the nature of development. It's still residential development. So even if the principle in Cadogan is right that you can't change the nature of development, that's simply another way, we say, of saying that you can't substantially alter the development. Paragraph 43, Lord Justice Lewison then says, if the inspector had left the description of the permitted development intact, there would, in my judgment, have been a conflict between what was permitted, 100 metre turbine, and what the new condition required, 125 metre turbine. A condition altering the nature of what was permitted would have been unlawful. That, no doubt, was why the inspector changed the description of the permitted development. In my submission, that is simply another way of saying one cannot substantially alter. Well, those are the authorities.
Thank you.
I'm conscious I haven't drawn together our submissions and why we say Mr. Justice has got it wrong, but I'm also conscious of the time. I suspect that my learned junior is going to take a little more than 10 minutes to go through the relevant propositions.
Well, let's keep going till 1 o'clock, and then you two can, all of you can discuss it after lunch, the break. How long do you think you're likely to be, Mr. Bergen?
Well, my lord, I haven't heard Mr. Williams yet.
No.
I understand. We're not quite at the end of ground.
Did you not discuss? I mean, we're listed for a day, so I infer that you must have liaised about timetabling beforehand.
Well, my lord, we suggested a longer timetable than has been permitted by the court. So,
Well, I appreciate that, but then, not that any of us were party to that,
no.
but then you all have to cut your cloth to what has been permitted. And it's not permissible simply just to say, well, I wanted longer and I'll carry on.
Well, I wasn't suggesting that for a moment.
Right, no. Okay, well, let's not waste time and use the time till 1 o'clock efficiently.
Thank you, my lord. I have set out, we have set out, forgive me, in our skeleton argument, the reasons why we say the judge below got it wrong. At page 18, we set out our submissions,
Yeah.
and we set out at paragraph 50 the passages in Mr. Justice Morris's judgment that we take issue with. And he derived the following, it's his judgment, paragraph 124, our paragraph 50. Under section 70, there is no power to introduce a condition which creates a conflict or is inconsistent with the operative wording of the existing original planning permission. This is restriction 1. In our submission, that's not correct. The words of grant are always subject to the terms of the conditions. What is impermissible is the second restriction, which he refers to as 2, either fundamental alteration or substantial alteration. Not permissible, we accept that. 124.4, Mr. Justice Morris made it clear that any inconsistency was fatal. Restriction 1 is not limited to a case where the conflict or inconsistency with the operative wording is fundamental. It suffices that there's any conflict. It encompasses the position where the condition alters the nature and extent of the grant, i.e. is found in the operative wording.
And you say that's all far too wide?
Far too wide.
Yeah.
The reasons we say it's too wide are set out at paragraph 51 of our skeleton argument. First, as a matter of statutory language, there's nothing in section 70, 72 or 73 that prevents a local authority from doing this. On the contrary, its statutory scheme leaves it to the local authority to decide what it grants and how it expresses the grant.
There you're referring in particular to section 70 and possibly 72.
Well, yeah.
Okay.
But in my submission, the power to impose conditions under section 73 is no less extensive. 2, we say it's wrong to draw this distinction between the operative words and the conditions. When you look at what is permitted, you need to look at both. Three, we refer to case law, which we've taken your lordships to. 4, we say Arrowcroft supports our approach, properly understood. 5, so far as the case of Finney is concerned, we say it should be narrowly, or rather understood as dealing with a very narrow issue, whether you can change the words of grant under section 73 of the original permission. You can't do that, we accept that, but it has no, in our respectful submission, no bearing on the scope to impose conditions under section 73. Likewise, we say Cadogan properly construed doesn't actually prevent this either. Our 7, Mr. Justice Morris refers to Kent County Council and Stevens and says there's a difference in principle between modifying a proposal by a condition imposed under section 70 and changing a condition to an existing grant under section 73. Well, with respect, there's no difference at all. Of course, the clearer way to modify the scope of development is to change the words of grant. My Lord Justice Holgate is entirely right, of course, that is the neater, clearer way to do it, but all these cases about imposing conditions cutting down, they arise because that's not done, that is often not done. The words of grant are left, and it's the condition that does the work of reducing the scope of the permission. We say that's perfectly permissible under section 70, also under section 73. And so far, R9, so far as the practical application of the principle is concerned, the no conflict restriction, well, that would depend very much, it would appear, on the words of grant, which will vary from case to case and applicant to applicant. Essentially, we say this principle doesn't serve a good planning purpose. It's an important flexibility, we submit, that local planning authorities can, through the imposition of conditions, modify the scope of permission. It's an important flexibility, and there's no need to cut it down in this way. So far as ground 2 is concerned, that's a matter of judgment. Was there a substantial alteration in this case or not? And I think for reasons I've already covered, we submit there was no substantial alteration, merely because the substation referred to has been omitted from the plans. It was an ancillary, discrete element, and it could be omitted without changing the nature of the proposal. My Lord, I've taken up quite enough time.
Well, that takes as such, but you did have to deal with an awful lot of questions. So that's your grounds 1 and 2.
Oh, yes.
Mr. Williams, do you have any guesstimate as to how long you're going to be?
I would hope on grounds 3 and 4 to get it wrapped up in certainly less than half an hour, and I'll try and cut that down to 20 minutes.
Right.
I can take it to the counter.
Mr. Burton, if it is 20 minutes, does that give you sufficient time for reply? I mean, we can sit till 4:30.
I believe it should, my lord.
Good. Okay. And it may be that, Mr. Gibbon, your final reply will have to be even truncated. But we'll hopefully, with goodwill on all sides, we can get through it. Anyway, thank you all very much indeed for the hard work, and we look forward to seeing you at 2 o'clock.
Court rise in Avon.